Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, listen, there is a case that is sitting on review or petition for review before the United States Supreme Court that deals with bump stocks, but it actually may have very, very far-reaching implications as it relates to all of the alphabet agencies, in particular ATF, and most in particular, what the ATF is currently doing with Operation Reticent Recall, which is their scavenger hunt for solvent traps, force reset triggers, and wide open triggers, and what their nefarious plans may also be for pistols and firearms with attached stabilizing braces. So today, I want to spend a few minutes and get you guys all up to speed about the bump stock case that the ATF should be worried about. Okay, so the case we're talking about today is hot off the presses here. It's a case called McHutchen versus the United States. Now, McHutchen is a bump stock case, and I know some of you are rolling your eyes and you're like, man, didn't the Supreme Court just reject bump stock cases? Yes, it has not. Bump stock litigation failed everywhere miserably. The answer is yes, it has, okay? This is not a suit, however, that is grounded in the Second Amendment. No. You see, this is not about whether or not ATF had the authority to actually regulate bump stocks or not, whether or not bump stocks should have been deemed illegal. That's not the focus of this lawsuit. So it's not about the Second Amendment. No, instead, this is about the Fifth Amendment. And you're going, well, what does the Fifth Amendment have to do with any of this? Well, we know that the Fifth Amendment guarantees us due process under the law, but it guarantees us much more than that, including something called constitutional takings, okay? And let me explain to you this in a minute, but first, here's how the Fifth Amendment itself reads. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces, or in the militia, when in actual service in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor shall be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay, so the first 90% of the Fifth Amendment, you all know that, okay? There is due process under the law. You cannot be sent to jail or prosecuted for a crime without the proper due process, both substantive and procedural, being followed, including notice and a meaningful opportunity to be heard, the ability to confront all of your accusers, your presumption of innocence, your right to remain silent. All of these things are inherent in the Fifth Amendment, okay? However, what's also inherent in the Fifth Amendment is that when government just takes your property, they have to compensate you for it. Okay, so how does this relate to bump stocks? Well, if we go back in our time machine here, we will remember that the ATF on multiple occasions had previously determined that bump stocks did not in any way, shape, or form constitute machine guns or components thereof under federal law. As a matter of fact, there was at least one, and it may have even been two, ATF letters that were published under the Obama administration. That's right, under the Obama administration, that said, hey, we don't have a beef with bump stocks, okay? Fast forward, of course, to October 1st of 2017. The largest mass shooting in the history of our country took place on the Las Vegas Strip when a madman opened fire from across the street at the Mandalay Bay into a country western concert. Many of the firearms that he had were equipped, or at least allegedly equipped, with bump stock technology. That led then President Trump to actually direct the ATF to take another look-see at bump stocks with a strong directive to now find them to be unlawful. By the way, is any of this beginning to sound familiar? ATF makes a previous determination, then political winds change, and now there's executive pressure to perhaps go back and change your position on that. Well, that's exactly what the ATF did with bump stocks, and when they did it, they really meant it, because as of a date certain, the effective date of that rule, bump stocks became unlawful. There was no grandfathering clause in there whatsoever, okay? It was as of that date, the property owners had two choices. Either A, destroy their property, or B, surrender their property to government, okay? That was their two options. Now, I don't know how much bump stocks were running back in those days, but every single one of those owners had money invested, had their own personal finances invested in that equipment. And overnight, just like that, they now have to turn these things in, or if they don't, they are threatened with what? Prosecution of the law. It would almost be like the ATF, oh, I don't know, saying that force reset triggers were okay, and then changing their mind, and then showing up at your door saying, hey, either give us their trigger, or we might have to prosecute you for federal crime. Not like that would ever happen, okay? Now, here's the thing. What the plaintiffs are challenging in this case, it's not that you took our property from us. It's not that you ruled that these bump stocks were now unlawful. That's not the focus of this challenge. The challenge is, hey, the Fifth Amendment guarantees that when you take property from us, you have to give us just compensation. And you know how much we got compensated for all the bump stocks that either we had to turn in or destroy? Yeah, that'd be zero. Okay, and this was under a government order. And remember, this was also not only under a government order, this is under a threat of criminal prosecution if you don't comply with the government order. Now, listen, in the lower courts, okay, the plaintiffs here got smacked down in some really bad ways, but this is one of the most alarming things. One of the lower courts, in justifying why government could do this, said that, listen, because this device, this bump stock, could have potentially been regulated by the ATF, and everyone knew that when they bought it, and because there was a mere possibility that the ATF could change direction on it, that no one ever truly vested a property interest in it. That's right. Let me say that again. Because you purchased an item that could have been more federally regulated by an alphabet agency, not just the ATF, it could be anybody, that you really didn't have a vested interest in that property, and therefore when government took it from you, you were not entitled to just compensation. Now let's just say, for example, if we take that logic to any other conclusionary level that we could go. For example, the EPA decides, oh, you know what? Gas-burning cars, yeah, they're unlawful at this point now. They're harmful. So all of a sudden, because of that rulemaking in the EPA, they suddenly can pull all these cars off the road and they're not compensating you for that. Let's say that the FCC decides that the way you run your internet or the way you use your cell phone is unhealthy or unlawful in some fashion or against some regulatory scheme, and therefore you need to surrender that phone or you need to change to a new, greener technology cell phone, and if you don't do so, you're subject to either some type of civil fine or criminal prosecution. Do we honestly believe that any piece of personal property that we buy, which could be regulated at some point by an alphabet agency, by an executive agency, means that we don't have a vested interest in that? If it could be regulated by the EPA, if it could be regulated by the FCC, if it could be regulated by the Food and Drug Administration, if it could be regulated by the IRS, you see where this logical conclusion takes us, which is, are you telling me that we actually never have any vested property interest in anything that government might be able to regulate? Because that's just about everything. The plaintiff's counsel, I think, best sums up their position like this. When ATF reversed course, issuing regulations that interpreted Section 922.0 to prohibit such devices, it did not grandfather in the existing bump stocks. Instead, it required petitioners to surrender or destroy them. That is a quintessential taking of personal property. Petitioners were both physically dispossessed and denied all beneficial use of their bump stock. And that's exactly what occurred here. And again, so what the petitioners are claiming is listen, it's not about the rulemaking, the fact that this stuff was ruled illegal and taken from us. It's that when they took it from us, we didn't get compensated for it. And in asking why the Supreme Court should accept review, petitioners' counsel was very wise to point out, this is no small matter. The overnight conversion of petitioners' property from legal to illegal affected hundreds of thousands of devices worth tens of millions of dollars. But the principle at stake is even more astounding taken to its logical end. The Federal Circuit's reasoning would authorize the administrative state, which touches nearly every feature of modern life, to extinguish all sorts of personal property rights via publications in the Federal Register. This court should grant review to decide whether the Fifth Amendment can so easily be evaded. And I would go one step further, which is not easily evaded, but essentially eviscerated altogether. And also, one of the things that the petitioner points out, and I always think this is a good legal strategy, is to point out how easily it would have been to do this in a more appropriate fashion. Now, they relied on a case that involved a Native American who was selling eagle feathers, and then there was changes to Fish and Wildlife regulations, which made the sale of those feathers unlawful, essentially putting her out of business. Now, she claimed that that had been an unlawful taking, but the court very justifiably ruled that no, it had only regulated that form of business. She was still allowed to keep those feathers. She could do other things with those feathers. What she couldn't do was sell them commercially. Now, that's entirely different than what happened with the bump stocks here, because there was a date certain. It came and it showed up on the calendar one day, and that was a date where, listen, either you destroy your bump stock, you surrender your bump stock, or you face criminal prosecution, and there was no gray area. The plaintiff's counsel correctly pointed out, none of this is to say that some form of bump stock ban couldn't have been implemented without affecting a taking. ATF could have just grandfathered in existing devices and imposed its ban on a prospective basis, which in many ways is what Washington State did in its magazine ban. Now, I'm not sticking up for Washington State's magazine ban, but it did avoid some of the constitutional deficiencies, certainly not all of them. But the importance of the takings clause and the importance of this component of the Fifth Amendment can really be summarized as follows. The takings clause is designed not to limit governmental interference with property rights per se, but rather to secure compensation in the event of otherwise proper interference amounting to a taking. So again, what the plaintiffs are saying here is, listen, we're not arguing about the fact that you took this stuff. What we're arguing about is you didn't give me the fair market value of the property you took me. You left me with no choice but to dispossess myself of the property, but then I didn't get just compensation as what's mandated by the Fifth Amendment. Now, let's take a look at where this case could go if it's accepted by the United States Supreme Court. Number one, the arguments here are exceptionally well crafted by the petitioner's counsel, but also the lower court's ruling is such a abomination of the Fifth Amendment that there is no doubt in my mind that the Supreme Court would almost have to accept review just to correct the record on that. I do believe that this court is well situated, however, to make a very strong and definitive ruling that would assist this. But how does it affect the here and now? Well, here's what I'm talking about. Can you imagine this? An agency that changes course had previously issued open letters saying, hey, everything's fine, these are cool, and then finally, nope, these are not cool, and, oh, by the way, you need to give us the property or face criminal prosecution. Not like that would ever happen again, except that it is happening, and it's happening right now, especially with the forced reset trigger, okay? I'm not going to so much get into the solvent traps here, but on the forced reset trigger, there was multiple times where ATF had determined, not a machine gun. Then all of a sudden, it's a machine gun. And oh, by the way, you either need to destroy it or give it to us because otherwise you face criminal prosecution, okay? That's exactly what happened in this previous case here. So, this case, McHutchen versus the United States, has the ability to either completely undermine Operation Reticent Recall, which is the national scavenger hunt for triggers and traps, or to ultimately come with an incredibly large price tag. Now, for those of you still geeking out on this video, we're going to be doing another video about if you're receiving supplemental correspondence from ATF after surrendering a trigger or a trap, what you should or should not be doing to that, because that could have a significant effect. Let's take a look at another thing that ATF is kicking around right now, like, amending their Form 1 and dealing with firearms with attached stabilizing braces, which now could also create billions and billions of dollars of new tax revenue, essentially leaving you with a choice of destroy your firearm, surrender your firearm, pay a tax and register your firearm with the United States government, or become a criminal. All of which without just compensation of the law. So the case that we need to be really careful about, the case that we need to very carefully watch to see exactly what the Supreme Court does. Do we want to see the Supreme Court accept review? We most definitely do. The case again is McHutchen versus the United States, and it is the case that the ATF should be very, very worried about. Listen, in the meantime, if you have any questions about this case or anything else related to your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com, or, of course, you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.